Welcome back, everybody. We're continuing our trial recap out of Illinois as defendant Bradley Yohn acted as his own defense counsel for a second day on Wednesday. Yohn faces burglary, carjacking, kidnapping, and sexual assault charges for a November 2021 incident involving 77-year-old Tina Schmitt. The victim ended up dying a month after the attack, but prosecutors haven't pursued murder charges. However, prosecutors do believe that the trauma that Schmitt endured did play a role in her death. As Yohn faces life in prison, he's choosing to represent himself in court and has done so for the past 2 days. In the last segment, we looked at an interesting exchange outside the presence of the jury from Wednesday morning, and that ended in one of Yohn's relatives getting banned from the courtroom. So let's take a look at how testimony has been going as both prosecutors and Yohn himself got a chance to address witnesses. Sergeant Joe Lohmeyer, a first responder at the scene, testified about Schmitt's demeanor following the attack, and Yohn did some attacking of his own in court.
She was on the floor. There was some crying, but it was also, I think, what I've seen in other people, a shock. There was like a pain for kind of remembering it, you know, and some hesitation. And it was kind of a little bit disjointed as far as how the conversation went.
What would you say if I made a statement that some of the things you have relayed here today are contrary to maybe what the person...
Objection, improper impeachment.
I'll sustain the objection. You may rephrase the question.
Several times throughout these witness testimonies thus far, witnesses have looked directly over at the state's attorneys for guidance. Mr. Lohmeyer just did a moment ago.
Mr. Yohn, have you noticed either of the assistant state's attorneys giving an answer to the witness?
I tried to look and catch it this time, but no, I have not, Your Honor.
Okay, neither has the court. And so where the witness looks while answering questions, I cannot control. But unless the assistant state's attorneys are indicating some kind of answer that they should be giving, there's no reason to basically uphold your objection.
Joseph, let me start with you. So, Mr. Yohn, he isn't charged with murder. The prosecution, though, has heavily suggested that Schmitt died from the stress of this encounter months later. Is that a real thing medically?
Oh, yeah. Yeah, it is. I go back to the old analogy. There's the old poem about for the want of a nail, a horseshoe was lost, so forth and so on. And you have this intersection of these events that occur. So the question, I think, from at least a philosophical standpoint, you have to ask, had she not had this encounter that particular evening, would this precious woman still be with us? And I think that can be rightly asked and answered at this point in time. Of course, the court might not see it that way. Certainly prosecution at this point in time doesn't seem like they're pursuing that. But yeah, I think that I've been involved in cases where people have died as a result of a heart attack, as a result of having a weapon placed in their face, and that person was convicted as a result of that. I remember that very distinctly.
Yeah. Well, Brian, we joke around about it. It doesn't look like Yohn's doing a really good job of representing himself. That's my take. I mean, are there advantages to going pro se, though, that may help him that we're not thinking of?
So as a defense attorney, we often say that all the discovery in the world is amazing, but the best source of discovery is your client. The difference is when you get that information from your client, you filter it through a legal lens, and there you have the ability to make the objections, you have the ability to cross-examine, to bring in evidence, because you know how that comes in. It's, as I tell my clients, it's one thing to know what happened, it's another thing to be able to prove it. And so he knows what happened more so than anyone else, especially in a case where the victim, he's not being charged with murder, but died. So they're not gonna have their star witness. He could be the star witness himself, but he just doesn't know how to move in the court of law properly.
That's a good point. So with the proper, legal education, maybe he would have been a formidable, enemy to the prosecution, or a formidable foe if he knew the right questions to ask, because he knows the story better than others. That's a good point. Well, I'll tell you what, coming up, whether you're a multi-million-dollar celebrity or just a regular Joe, it is a good idea to have a will. And we have an update for you on which will governs the late Aretha Franklin's estate, after multiple were found scribbled on pieces of paper. And we end today's show with an update for you, and also a reminder, and that is always a good idea to have a written will. A Michigan jury decided that a handwritten note found under a couch cushion is the true will of the late soul superstar Aretha Franklin. The will was written in 2014, more recently than another one being considered, which was written in 2010. Franklin, known as the Queen of Soul, died in 2018 from pancreatic cancer at the age of 76. Her niece found 3 handwritten wills in Franklin's home after her death. The argument over which will was valid has divided Franklin's sons. Her youngest son, who goes by Kel, is named as executor in the most recent will. That will also states that Kel and Franklin's grandchildren are entitled to her home in Bloomfield Hills, Michigan. Now, both versions of the will allow her 4 sons to benefit from music royalties and copyrights. But let's talk about this. So, Joseph, the will that was not notarized and that was found under the couch was the will that was found to be valid. What's your reaction when you heard that?
Well, my friends that are question document examiners right now are probably thrilled about this, because this is going to be a perfect case for them to teach when it comes to forensic document examination. It's fascinating to me that someone at this level, and I have the ultimate respect for her, would, leave this, I don't know, this fortune, her life, I mean, her legacy unguarded, and not have something officially filed. I am, I don't know, gobsmacked over the fact that they went with the one that was not notarized. That's pretty fascinating to me.
Yeah, it was the later one. All you need is signed, dated, and true intention. It's the holographic wills in Michigan. I mean, Brian, one of the arguments during trial was that it didn't matter where the will was found. A will is a will. Is that true?
That's true, especially you already articulated the requirements for Michigan. Michigan is one of 26 states in the U.S. New York is not one of them that allow for these handwritten or holographic wills. Now, in the closing arguments for both Kel and Edward Franklin, the opening statement was out of the first line of that 2014 will, where Aretha Franklin says, "This is my will." And where the heart of the argument comes down to what is her intent, yes, Joseph Scott Morgan is right. It's notarized. That makes sense. Why is it not that one? But when she starts off with, "This is my will," that clearly was enough for the jury, who decided this case in less than an hour. But the battle is still not done. We just know which will is going to be followed. Now the question is the details. And I think both sides have to file motions to see who's going to be the executor, how's it all work out.
Yeah, it's an interesting case, but at the end of the day, maybe have a written will with witnesses and follow the requirements. Maybe it would make things easier.